In Lecture 3, we're going to study the political worldview of American law and government. And it's our intent that you're going to be able to identify the principles of American political theory and their historic sources. Also, we want you to be able to identify the major problem facing the framers of our Constitution and their formula for addressing the problem. With Lecture 3, here's Jake MacAulay.
As we begin Lecture 3, we're going to discuss the major influences on the Founding Fathers. To do that, of course, we bring up the Bible. Last week we looked at the study that Dr. Lutz and Dr. Heinemann did. We found that 34% of quotations from our framers came from the Bible. Secondly, we have human authors that are most quoted. Baron Charles Montesquieu, who was a French Catholic, was quoted 8.3%. He was the most quoted human author. His main work was The Spirit of the Laws, written in 1748, and his main contributions to the framers' thought was that God is the author of all law, physical laws and moral laws. And because of man's sinful nature, man departs from God's laws, and civil government is necessary to keep men within the confines of God's law. But in doing that, civil government is populated with men with the same sinful nature. So to keep government moderate, it is best to separate government power into three branches. This is where that concept comes from, the legislative, executive, and judicial. It's also found in the Bible in Isaiah 33:22. Christianity makes government more humane. So he seasons this whole formula together with Christianity because that's what keeps us humane as humans. He compared Christianity to Islam and declared that Christianity is superior partly because of the better government that it promotes. A moderate government is most agreeable to the Christian religion, and a despotic government to the Mohammedan. The Christian religion, which ordains that men should love each other, would without a doubt have every nation blessed with the best civil, the best political laws. While the Mohammedan princes incessantly give or receive death, the religion of the Christian renders their princes less timid and consequently less cruel. Our second most quoted human author here is William Blackstone at 7.9%. He was an Anglican, which was the Church of England, or Episcopalian as they were known of in the colonies. His main work was the commentaries on the laws of England, and the contribution to the framers' thoughts was a better understanding of this English common law and how it was applicable in the American courts. Judicial restraint was another topic that he discussed at length. Judges do not make law. They merely discover and apply the law. A great way to understand that is referees. Referees do not create the rules, but they are bound by the rules, and they are to apply the rules to the game and to the players. He came up with three categories of law in his writings, the first of which was the law of nature. And we get that from Scripture. When he created man and endued him with free will to conduct himself, said Blackstone, in all parts of life, he laid down certain immutable laws of human nature, whereby that free will is in some degree regulated and restrained, and gave him also the faculty of reason to discover the purpose of those laws. Secondly, we have revealed law. Now, this is because of God's compassion and mercy. We can't understand everything by looking into nature because nature is fallen. So God gave us His revealed law and made it plain and simple. He, that is God, gave us that in the Bible, such as the Ten Commandments. The doctrines thus delivered we call the revealed or divine law, and they are to be found only in Holy Scriptures, said Blackstone. Thirdly, there's municipal law. This is man-made law, and that is adopted by the civil governments, but it must conform to the higher law of God, said Blackstone. Upon these two foundations, the law of nature and the law of revelation, the Bible, depend all human laws. That is to say, no human law should be suffered to contradict these. Now that we've identified the three forms of law that Blackstone gives us, next it's the application of those forms of law in the court system itself. So the proper understanding of what precedent is. Most of our judges rule by precedent in this day and age. Understanding that is very important, just like understanding what separation of church and state truly means. Blackstone states, "For it is an established rule to abide by former precedents, where the same points come again in litigation, as well to keep the scale of justice even and steady, and not liable to waver with every new judge's opinion, he being sworn to determine, not according to his own private judgment, but according to the known laws. Yet," Blackstone continues, "this rule admits of exception." So these are the times when you don't abide by precedent, where the former determination is most evidently contrary to reason. We've identified that as the law of nature, much more if it be contrary to the divine law. For if it be found that the former decision or precedent is manifestly absurd or unjust, it is declared not that such a sentence was bad law, but that it was not law. So what we're stating in this paragraph in your notebook is, firstly, there is precedent, and what is precedent, and where should we stick to precedent? And secondly, in the second paragraph, we determine when we don't abide by precedent, when a judge shouldn't. And the times when he doesn't abide by that precedent is if that precedent does not square with the source, the authority of law, the laws of nature, and nature's God. We also have a DVD available on this called The Case Against Case Law that Michael Anthony Peruca expounds this more in depth. And I encourage you to watch that because there is a lot of little nuances that come into play here and its application in this day and age. Next in the line of human authors is John Locke. John Locke was raised in a Puritan family. He was basically Christian, though he was not entirely orthodox, and his main works that the founders cited were the first treatise on civil government, the second treatise on civil government, and then some would even consider him a theologian, as he wrote the essay concerning human understanding of St. Paul's epistles by consulting St. Paul himself, and also another work on the reasonableness of the Christian faith. His main contributions to the framers' thoughts were that government is established by covenant or contract of the people, and this was ultimately based upon, and I'm giving you a direct quote, "that paction which God made with Noah after the deluge," and that's found in Genesis 9:6. "And that whosoever sheddeth man's blood, by man shall his blood be shed, for in the image of God made he man." God has ordained the law of nature, to which all human laws must be subordinate. And thirdly, dealing with this law of nature, he discusses our God-given natural rights, and those are chiefly life, liberty, and property. Now we move on to other thinkers of international law, such as Grotius from Holland, Pufendorf from Germany, or Vattel, who is from Switzerland. They stress that international law must be based upon revealed law and the law of nature, again echoing Blackstone's sentiments. Our founders also quoted Roman thinkers, Virgil, Cicero, Seneca, Marcus Aurelius. These are those of which stress the virtue of the old Roman Republic and also the disciplines of that republic against the later excess of the empire. Non-Christian sources were cited as well, but often negatively. There were sources like Plato, Voltaire, Jean-Jacques Rousseau, Thomas Hobbes, and David Hume. The framers viewed their non-Christian philosophies as being unacceptable. Moving on, we're going to discuss the political philosophies that sprang from these religious views that we discussed in our last lecture. The reliance, as an example, upon the laws of nature and nature's God. And the sources of this concept, first and foremost being the Bible. Founding Father Noah Webster summed up the definitions of these terms as the 10 Commandments written by the finger of God and the underwritten laws on your God-given conscience. In other words, there exists a higher law than the law of man by which man's law must be judged. As a matter of fact, the Declaration of Independence makes absolutely no sense unless there is a higher law than man's law, or the king's law at that particular time. Natural law is also predicated upon the existence of absolute truth. This goes back to our presuppositions of American government in Lecture 1. There's a false view of natural law as well, that which exists in nature. Thomas Hobbes, who was an English philosopher, aligned his thinking with philosophers like Cicero, who believed there was no need to look outside of ourselves for an expounder or interpreter of natural law. But we have to understand that nature has fallen. Look at Romans 8, Verse 20 through 22, "For the creature was made subject to vanity, for we know that the whole creation groaneth and travaileth in pain together until now." Now the last point is that natural law limits government authority because, as we move into our next point, we have natural rights. So law is created literally to protect your rights. You can see how the law of nature would then limit an out-of-control government that would be encroaching upon your rights. As we discuss natural rights, we find that they are rooted in the law of nature. That's where we can find them. That's where we can look to. The source of natural rights, of course, is God. We have God-given rights. And this is based on man being created in the image of God, possessing human dignity. This is also based on the negative commands of Scripture, "Thou shalt not kill." Thus you have the right to life given by God. He protects it by giving that law, "Thou shalt not kill." Natural rights existed as a limit on government authority. Remember that concept. Now, our natural rights consist of, but they're not just to be contained in, the following points. Number one, life. This is basic for exercising all other rights, which would include liberty. Liberty is defined in part by Noah Webster as the power of acting as one sees fit without any restraint, except from the laws of nature. The laws of nature and nature's God are the revealed law in the Bible, including the Ten Commandments and your God-given conscience. So liberty is not just the freedom to do as you please, but rather true liberty is the freedom to choose to do what is right according to the will of God. Property. This is not just material gain. This is a natural right, but it's not found in how much stuff I have. Property was viewed as a means of productivity by our framers and also by God. That's why He gives it and gives us the right to it. Property was viewed as an extension of the person. As an example, I work all day long mostly on a computer. That computer is my property. It's an extension of who I am, and therefore it helps me to do more things, to be more productive. Lastly, we come to the pursuit of happiness as basic natural rights. This included property, but it expanded upon that, and I believe Jefferson wanted that, and that's why he chose those words. This can be equated with the pursuit of virtue. Virtue is the only basis for genuine, lasting happiness. A non-virtuous person is not going to last long in happiness. Each of the states recognized and understood these rights, where they began and where they all ended, as illustrated by Maryland's Declaration of Rights, which stated that as it is the duty of every man to worship God in such a manner as he thinks, notice the lowercase h in he, most acceptable to him, the uppercase, referring to God. All persons are equally entitled to the protection in their religious liberty. Wherefore no person ought by any law to be molested in his person or estate on account of his religious persuasion or profession, or for his religious practice, unless, under the color of religion, he shall disturb the good order, peace, or safety of the state, or shall infringe the laws of morality, or injure others in their natural, civil, or religious rights. Let's move to equality. This concept of equality is not equality of outcomes, but rather it's the equality that God created. He created us all in His image. But I do want to touch on this because would it be fair, and I think most of America would be up in arms, if a referee stopped a game and said, "Hey, we've got to be equal here. We need to give the other team a few more points." And he shot the basketball into their hoop. People would be outraged. That's not equality, and that is not the equality that our founders meant, nor is it the equality that God gives. We're born equal, and God is no respecter of persons. You can see that in Acts 10:34. And in Galatians, Paul says, there is neither Jew nor Greek, there is neither bond nor free, there is neither male nor female, for all are one in Christ Jesus. As a matter of fact, the Old Testament law prohibited partiality in judging, and it wasn't just being partial to rich people, it was being partial to poor. The prophets condemned judges for their partiality in the Old Testament. Another political view that sprang from the religious beliefs of our founders was government by the consent of the governed. This is clearly an established principle in God's law, and we cite numerous examples here from the Old Testament. I'll pick one. Judges 8:22, "Then the men of Israel said unto Gideon, Rule thou over us, both thou and thy son." He didn't usurp the throne. He was being asked by the people. He's being selected by the people, by their consent. In our own self-government, we must establish, as the framers did, that God is the source of all authority. This is referring not just to power, but legal power. That is, power according to the laws of nature and nature's God. This means the Romans 13 directive to submit to governing authorities is commanding submission to those who rule according to the laws of nature and nature's God, but not to those who exercise power outside of God-given authority. Daniel is a great example of this. He obeyed a pagan king until he commanded Daniel to worship him rather than God. This concept of God as the source of all authority was clearly recognized by the colonial charters. God delegated authority to civil government through the people. They were the instrument that was used. This is also a great example of John Locke's social contract theory. Another political ideal that springs from religious beliefs is the recognition of the sinfulness of human nature. The framers believed that men were self-interested. They were sinful. They were corrupted, just as the Bible describes. And James Madison made the statement, if men were angels, no government would be necessary. Although we even find in the Bible where some angels needed to be governed. But he continues, if angels were to govern men, neither external or internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed. And in the next place, oblige it to control itself. This is what it came down to. This was the end of the funnel, if you will. Alexander Hamilton made the statement, till the millennium comes, in spite of all of our boasted light and purification, hypocrisy and treachery will continue to be the most successful commodities in the political market. Our founders therefore believed that government was needed to curb men's sinful nature. But they also knew that the rulers in government and their officials have the same sinful nature as all the rest of us. So for that reason, they feared government power, and rightly so. Power tends to corrupt, said Lord Acton. And when you give that power absolute power, it will corrupt absolutely. For that reason, God has limited government power. But we find now in this day and age, as from even the conception of our limited government, that it has eroded. Modern politicians now have largely abandoned the American view of law and government. And we give a couple examples in our notebook here of congressmen that give their philosophy, and you'll notice that their philosophy is antithetical to the philosophy that we just discussed that sprang from the religious underpinnings of our founders. What these representatives are espousing essentially is socialism. And I'd like to share with you a clip that illustrates this socialist view of government by our founder, Mr. Michael Anthony Peroutka.
Imagine you and I are strolling down the street one fine day on our way to have a nice lunch, and we come across a woman who is truly destitute. She needs many things, including food to feed her baby. Imagine also that you just cashed a check, and you know and I know that you have $200 in your pocket. Now imagine that I decide that you should give the $200 to the woman. Remember, she is truly needy. So I take out my handgun and I order you at gunpoint to turn over the $200 to the woman. And so you comply. But it's not over. Let's just say that I am so moved by this woman's situation that I order you to come to my house tomorrow and the next day and every day until you die and give me more money so that I can provide for her and her children and her grandchildren indefinitely. Furthermore, I make it clear to you that if you do not do as I command, I will use force against you and your loved ones. Of course, if I behave this way towards you, I would be acting criminally because I have no right to force you to part with your property, even if the cause is a worthy one. Well, the question then becomes, would this action on my part be legal and righteous if it was done not just by me, but collectively? Let's say everybody on the whole street agrees that we should take your money and give it to the needy woman. Is there any moral principle that makes collective force acceptable when the use of force individually would be a crime? And the answer is, of course, no.
So now that we've worked through the list of the religious beliefs that transcended into the political philosophy of our framers, we come to the issue that the framers faced at the convention. how to give government enough power to govern effectively, but then limit that power so that government does not become tyrannical and corrupt, given the fallen nature of men. Well, the answer is don't let any individual or agency become too powerful. And the method on how to do this is what we call the Founding Fathers' five-fold formula. And the first in that formula is limited delegated powers. Jefferson said, bind men down with the chains of the Constitution. In other words, if something is not specifically mentioned in the Constitution, the federal government has no authority in that area, such as marriage, education, or health care. Secondly, we have a vertical division of powers. This is your federal, state, and local divisions. Then you have a horizontal separation of powers through a legislative, executive, and judicial branch, and also what many folks commonly term a fourth branch of government being the jury. Next you have checks and balances, and finally you have reserved individual rights that no government or agency can encroach on. So to summarize, we can clearly see that our framers believed that freedom was impossible without virtue. Well, they also knew that humans, in and of themselves, possess no virtue at all. So how do we provide virtue? Or do we just say this thing isn't going to work? This is impossible. It's an impossibility. Well, they relied upon religion and Christianity. You can see George Washington in his farewell address said, of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. John Adams said, our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. So the solution to the problem, as our founders saw it, was religion, Christianity, because only a moral and religious people are capable of self-government. Thank you so much.